We're on the record as the people of the state of Michigan versus Javante Bussell, 2355383. Mr. Bussell is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony firearms. Count 3, assault with a dangerous weapon, felonious assault. Count 4, weapons, felony firearms. Count 5, malicious destruction of personal property, $1,000 or more, but less than $20,000. Count 6, weapons, felony firearms. This is a habitual offender's second offense notice. Mr. Cripps.
Good morning, Judge David Cripps, P 34972, appearing on behalf of my client Javante Bussell, who's joined us from the Wayne County Jail.
Mr. Bussell, can you state your name for the record, please?
Javante Bussell.
Good morning to you.
Good morning.
Okay, Mr. Cripps, there's no prosecutor yet in the courtroom. Do you want to wait for the prosecutor or move forward with setting a date?
I would like to move forward with setting a date, Your Honor, for an exam.
Okay, the earliest I have is the 27th of February. I also have the 28th and March 2nd as well.
I'm checking. March 1st, Your Honor, works fine for me.
You know what, March 1st, the court is closed for some reason. I have March 2nd open.
Okay, I'll take March 2nd.
Okay, 9:30, 10 o'clock, 10:30, or 11.
11 o'clock, Your Honor.
Okay.
You said 11 o'clock.
Okay, Mr. Bussell, you will be sent over for your exam to 36th District Court for March 2nd at 11 a.m. Okay?
Thank you.
You're welcome. Anything else, Mr. Cripps?
No, Judge, thank you very much.
You're welcome. Have a good
Have a
day.
good day. You too, Judge. I'll be calling you, Mr. Bussell.
I appreciate it.
You're all set, Mr. Bussell.
Thank you.
Attorney Perkins?
Yeah, good morning, Your Honor.
You don't like
Good
the
morning.
space?
Yes.
Okay.
I like that.
I
Okay, Attorney Perkins, you have something on the docket today.
Yes, Attorney Mercier has Mr. Ryan Binder on the docket today for PCC. He's in custody.
Okay, I don't see Mr. Binder on the screen yet. He's in the Wayne County Jail?
Yes, he is.
Okay, let me check on that. Thank you. See, it looks better right here.
Okay, well, we do it like this, so we can write our stuff. And some judges like. we would be something too. So that's how. Except for tomorrow. I mean, two.
Okay, Attorney Perkins, who do you have today?
I have, I don't have anything on the docket. But I do have the matter that the court had contacted me because Mr. Rose had indicated that I was going to be his counsel on Monday. He ultimately came in yesterday or the evening, the night before. And I wanted to alert the court or seek leave of the court to change the currently scheduled exam date, which is Monday, to another PCC because I don't have discovery. I did send a proposed discovery order to your clerk and to Mr. Decker, whom I believe is going to be your prosecutor this morning. In that email, I also copied the appointed attorney as in the interest of professional courtesy so that I can alert her, Ms. Sanford, that I would be coming in. I will ultimately, if necessary, to get a substitution of counsel for her on this matter. But that's why I included her, copied her in there, and I copied everyone so that it's very transparent.
Okay, so how about we schedule the PCC for what the exam date was? Is Monday?
Yes, that would, yeah, exactly, Your Honor. You're on the same page I'm on.
Okay, so we'll adjourn it to the 13th, PCC on the 13th, and I'll take the exam out of the, ROA.
Okay, and I did send that to Mr. Decker and for his consideration. If he has some objection, maybe if he doesn't get, if it doesn't get signed, I guess we could ask for it to be signed on Monday or make the changes then.
Okay, when he comes back in, I'll let him know.
Okay, thank you, Your Honor.
You're welcome. Have a good day.
All right, thank you, Ms. Knight.
Okay, Attorney Mercier,
Yes, Your Honor.
is that Mr. Ryan Bender or Binder?
Yes, it is, Your Honor.
Okay, all right.
Could I have a brief breakout room with him, Your Honor?
Sure. Is it Bender or Binder?
I say binder. BINDER.
Binder, okay. Mr. Binder, go ahead and hit join on your screen. It'll take you to a room so you can speak to your client in private. It should pop up in a couple of seconds, right about now. Okay, Attorney Howell, good morning.
Good morning, Judge.
How are you today?
I'm okay, Judge. Thank you. How are you?
Pretty good. Who do you have?
I have Mr. Baxter.
Devon Baxter. Okay. I don't, is he checking in and I don't see him?
Judge, no, he's not checked in. I am asking to waive his appearance for purposes of the PCC.
All right. And we actually have a prosecutor now, so
Yep.
we have. Good morning.
Good
I
morning.
see you getting ready for cases.
Yes, I'm here.
This is just a PCC for Mr. Baxter.
That's copy that.
Okay, we're on the record as the people of the state of Michigan versus Ryan Scott. I'm sorry. This is the wrong case.
John Brandon.
Javon Brandon Baxter, 2355408. Mr. Baxter is charged with one count of stolen property, receiving and concealing a motor vehicle, stated except for PCC appearances.
Good morning, Your Honor. Eric Decker, P859331 for the people.
And good morning, Tiffany Howe on behalf of Mr. Baxter, P79667.
Any discovery issues?
Your Honor, I do have paper discovery. However, I do not have any video discovery. So if there is any, I am requesting it. And this time, my client is demanding his exam.
Okay. Mr. Decker, can you speak to the digital? Is it available?
I am not entirely sure it exists in this case, but if it does, I will make sure that we have it as soon as possible.
Okay, thank you.
So we have the 27th, 28th, and March 2nd as the earliest date.
The 27th, Your Honor.
Okay, how about 10:30?
Yes, that's fine.
2/27 at 10:30.
Yes, and I'm waiving your client's presence for the record.
Yes, thank you.
Okay, anything else?
No,
All right, you have a good day.
thank you, you too.
Attorney Mercier back and ready to be called, Your Honor.
Okay. Okay, this is case number 2355402. People of the state of Michigan versus Ryan Binder. Sorry, I still said it wrong. Count 1, assault with intent to murder. Count 2, assault with intent to murder. Count 3 and 4, assault with intent to do great bodily harm less than murder or by strangulation. Count 5 and 6, weapons, felony, firearm. Count 7 and 8, weapons, felony, firearm. This is a habitual offender. Second offense notice today, the date that we are probable cause for appearances.
Good morning, Your Honor. Eric Decker, P859331 for the people.
And good morning, Your Honor. Attorney Daniel Mercier representing Mr. Binder. Mr. Binder, please state your name for the record.
Ryan Scott Binder.
Is
Your Honor,
discovery issue?
I spoke with my client and we would be requesting an in-person exam on this matter.
Okay. You have discovery?
I don't have a hard copy and I'm not viewing my, I don't have access to my Dropbox right now. I'm on this Zoom. I can't confirm that, Your Honor.
Okay, you feel comfortable setting an exam without discovery or,
I do, Your Honor. I have a good protocol with the Wayne County Prosecutor's Office. I feel comfortable setting.
okay,
Your Honor, may I clarify?
sure.
Okay, just to Attorney Mercer, is there when you say you don't have a hard copy, does that mean that you have not received any paper discovery yet, or?
No, it means I haven't printed off a hard copy in the file I have in front of me.
Okay.
I get your discovery by whatever, it's Axiom usually or whatever. I upload it to my Dropbox, which I then have on my laptop in the courtroom.
I'm gonna double check to make sure you have it. Thank you.
I appreciate that. Thank you.
Thank you.
Okay, is in custody. I have a spot open for February 15th at 10:30.
That works for me, Your Honor.
And Mr. Binder, can you state your full name for the record, please?
You say my name again? Who said it?
Yes, your full name.
Ryan Scott Binder, Your Honor.
Okay, so your preliminary exam will be February 15th at 10:30 a.m. It will be in person. And you will be brought over at the 36th District Court, okay?
And I'll be visiting you via Zoom in jail before then, Mr. Binder.
Okay.
Thank you.
Okay, anything else?
Nothing further, Your Honor. Oh, if I may address bond, Your Honor. My client informed me that when he was picked up, he is actually scheduled that day for valve surgery.
Replacement. I'm supposed to have a valve replacement. They already went into my heart.
Valve replacement.
I got a stent in my heart right now, so I'm trying to go get the surgery.
Mr. Binder, only one person can speak at a time, okay?
Oh,
I'll
yes,
give you
ma'am.
an
I'm sorry.
opportunity to speak. Let your attorney speak first, okay?
Yes, ma'am.
Thank you.
I would ask for my client to be able to be released on tether for medical purposes.
And I heard Mr. Binder speak of a heart valve or.
That's correct, Your Honor. He informed me that he had a heart valve surgery scheduled for the day he was taken into custody. And that needs to be rescheduled and performed as soon as possible.
Okay, has his file been marked medical at all? Because I was told, I called him to the jail. You have a medical wristband, Mr. Binder?
He does, Your Honor. He's holding up in the screen right now.
Okay, and did they indicate, Mr. Binder, at all that you would be scheduled to have the surgery done and they could transport you?
They're not trying to do nothing for me, Your Honor. And my doctor said this is emergency surgery right now. I have a thing called a stent put in there right now, and it's opening up my valve, but they can't keep that in there for a certain. They can only keep that in there for a certain amount of time. My cardiologist, the heart doctor, I'm supposed to have it at U of M Ann Arbor, and they're supposed to put an actual something in there. They're supposed to replace the valve, and that's my hope. I'm not really up to tune on what the words are and stuff for it, but right now I have it's a temporary stent inside my heart.
Okay, Mr. Binder. So, Your Honor, what I'm asking for is for him to be released at home arrest on a tether and only be allowed to leave that home to go to the medical procedure that he would be able to schedule and get put in place once he's out of the Wayne County Jail.
Your Honor, the people are very concerned. I mean, obviously, we have for the medical condition. However, the people will be very concerned about any kind of a home release for charges that are this serious. The people would be perfectly okay if he's just simply going to the hospital to have some kind of a procedure done. But the idea of having him released and gone home when the charges are this serious does not seem to be a good idea. We leave it to the court's discretion.
So, Attorney Mercy, is there any way for him to schedule or so that I can have some verification that he can actually get the procedure done?
I came in with the paperwork, Your Honor.
I believe the sheriff is already in possession of that paperwork.
Okay, but the appointment is passed already.
I can't make the appointment when I'm in here.
That's why I was talking to your attorney, actually.
Oh,
Right.
I'm
Yeah, no,
sorry, guys.
Your Honor, that's why I'm asking for the at-home release so he can schedule to get it done. Because he informed me when I was in the breakout room, he can't get that scheduled while in Wayne County Jail.
And where are you gonna be staying if I release you?
Same address they arrested me at, Your Honor. They came right to my house at 166 North Main Street. I'm gonna be at the same place. I'm not trying to run. I'm not trying to go nowhere. I was actually about to go turn myself in on all my warrants when they came and arrested me that day. I was on my way to the hospital, and I don't plan on going nowhere, Your Honor.
And what hospital is that for the court?
That's U of M Ann Arbor. It's the 3rd floor, and my doctor's name is Dr. Catella.
Thank you.
How do you spell that? Do you know?
It's Catala, Catella. He's part of the Carter. I can't say that word. Cardiologist. Cardiologist team at U of M.
Okay. So this is what I do. Since your exam is on the 15th next week, that'll be Wednesday.
Yes,
When you
ma'am.
come in, listen, I'm gonna release you on a personal bond with house arrest. You are not allowed to leave for anything except for that appointment if it has been scheduled by the 15th to even go see the doctor. You're
Yes,
not
ma'am.
allowed to go home for anything. You
Now,
understand
what if I have to stay in the hospital? Is that okay, Your Honor? Because I might have to stay in there for a few days.
If you're in the hospital for your treatment, that's fine.
Okay.
That's it.
Yes,
So
ma'am.
on 15th, if you're not in the hospital and you're here for your preliminary exam, I need to see some paperwork. I need to see some.
Yes,
type
ma'am.
of-
I'm gonna bring you everything that they give me.
Okay, so I'm going to reduce your bond, or I say adjust it to a personal house arrest with a tether.
Yes,
No
ma'am.
contact any of the complaining witnesses at the address that you just spoke to on the record, okay?
And then can I repeat that address to make sure you guys got it correctly, ma'am? Because I don't want no confusion or nothing. I want you guys to have, it's 166 North Main Street. That's MAIN. That's Britain, Michigan, BRITTON. And it's the zip code is 49229. It's like I live in a big farmhouse, so.
Do you
It's the
have a
same
phone?
house. Yeah, I have a
Phone number for you.
Area code 734-629-3451.
Thank you.
Okay,
I had to
so
catch your breath, sorry.
I will fill that form out now for your bond to be adjusted, and I will see you on the 15th with some documentation.
Thank you, Your Honor.
Thank you.
So in person, if I'm not in the hospital, I got one more question, just because
You call me if you're in the hospital. I'm going to notify the court, sir. I got your phone number. I'll call you and answer your questions.
I might
Okay?
not be able to talk, so could I have my wife do it? Because she will be there with me also. Like, could she do it on video?
Your wife can come on the 15th.
Okay,
So I didn't state this on the record, it's a personal bond, but it's $10,000 personal bond, okay?
Thank you, Your Honor.
Do you need to speak to your client after this?
I don't, Your Honor. I got all the information I need. I'm going to file with my client after he is at home. I have his phone number, and if he is in the hospital, I will notify the court prior to the hearing, okay?
Okay. All
Thank
right,
you.
you all have a good day.
Thank you.
thank you, Your Honor, very much. God bless you.
I hope everything works out with your heart.
Thank you.
Attorney Robinson, you're all set, Mr. Binder. Attorney Robinson?
Your Honor, this is Attorney Bates. I checked in already.
If the attorney's ready,
Legion, I gotta go.
Oh, so it's going early?
Yes.
yeah, we changed the date.
Okay. So I can bring people.
Give me like 5 minutes.
Okay.
Attorney White, are you ready?
With Nasser? Yeah, Lisa.
I am, Your Honor.
Four. Yeah. Are you waiving your client's presence?
I am. I still don't have the discovery. I guess this was a case where the prosecutor was trying to secure the discovery, so I still haven't received it. And I'm waiving her presence.
Hello,
Okay. Babe, what's your name? Who's just said hello?
Marlisha Ford.
Oh, okay, there she is.
I'm getting ready to call your case.
Okay.
The people of the state of Michigan versus Marlisha Ford, 2260868. Ms. Ford is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony firearm. Count 3, assault for assault and battery. Strike that. Ms. Marlisha Ford is defendant number 1. Charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony firearm. Count 3, assault for assault and battery, and a habitual offender second offense notice. Today's the date set for a probable cause conference appearances.
Good morning, Your Honor. Eric Decker, PA 5931 for the people.
Good morning, Your Honor. Coral Watt appearing on behalf of this court, P41508.
And Ms. Ford, can you state your name for the record, please? Ms. Ford, can you state your name, please?
Yes, I'm here. Marlisha Ford. Marlisha Renee Ford.
Thank you. Good morning.
Good morning.
Okay, so Attorney White, you say that you still don't have discovery?
I do not.
Your Your Honor, I'm looking at the notes here and I can confirm that it looks like there was none sent so far. I'm gonna get on this today and we'll make sure, we'll see what's going.
So it was adjourned from first to today to receive discovery.
That is correct, Your Honor.
Mr. Decker, you don't, because you weren't on the case, correct?
That's correct.
I know you're trying to figure it out.
I'm doing that right now.
Okay, Attorney White, can you give me a few moments to let the prosecutor, it's a different prosecutor today, Mr. Decker, who is not aware of what the issue is.
Okay, no problem, Your Honor.
Thank you. Attorney Bates.
Good morning, Your Honor. Sorry, I lost connection. I'm in Frank Murphy.
I know it's really bad internet up there. Okay, let's call the case 2355406, people of the state of Michigan versus Marcus David Williams Jr. Mr. Williams is charged with count 1, weapons, firearms, possession of a loaded firearm in or upon a vehicle. Appearance?
Your Honor, Decker, PA 5931 for the people.
And good morning, Your Honor. Melanie Bates, P76080, appearing on behalf of Marcus Williams. I see he is present on Zoom this morning.
Mr. Williams, can you unmute your device, turn on your camera, and state your name, please?
Yeah. Okay, I see.
Can you state your name, Mr. Williams? All right, any discovery issues?
Your Honor, I have not received discovery yet. I did order the discovery, so I'm requesting all paper and also digital discovery.
Okay. Mr. Decker?
Well, Your Honor, we will get that as soon as we can. Sorry, what is the, I'm sorry, I apologize, I'm trying to do a couple things at
I
once.
know, Marcus Williams.
Marcus Williams. Okay, from what I understand, there was, from looking at the notes on this one, it looks as though it was sent, there was perhaps another attorney and maybe that was sent, but we will get that to you today.
Okay, thank you.
You're welcome.
So with that, Attorney Bates, are you comfortable with setting the exam date?
Yes, I can set the exam date.
Okay, we have February 28th, March 2nd, and anything after March 2nd. So the earliest is the 28th.
The 28th would be fine.
Okay, I have 9 o'clock, 10 o'clock, and 10:30.
How about 10:30?
Okay. February 28th, 10:30 in person, Mr. Williams, do you understand that?
You said the 28th at 10:30 in person?
Correct.
Yes.
I could do that.
Okay, thank you. Nothing further. Everyone have a good day. I'll be in touch with you, Mr. Williams.
Yes, ma'am. Thank you.
Okay, bye-bye.
To the gentleman in the Wayne County Jail, 52, what is your name?
Paul Rice. Paul Anthony Rice.
Attorney Robinson?
Okay.
Attorney Robinson, can you hear me?
Yes, Judge, I can hear you.
Still don't have a competency report back from Mr. Rice.
Yes, Judge, I called the Forensic Center this morning and spoke to the scheduler about that.
What they said?
They said that he will be evaluated next week.
Did they say how long it would take for them to do the report?
They did not.
But can I get a personal bond? I've been sitting in here 3 months with nothing. And I got a personal
Nobody
bond
addressed you
already.
yet, Mr. Rice, we're not even on the record, 1 second.
Okay, sorry about that, ma'am.
It's fine, you'll have an opportunity to speak, hold on.
Sorry, Judge. I'm sorry.
We're on the record, this is people of the state of Michigan versus Paul and Tony Rice.
Sorry.
2260363, Mr. Rice is charged with count 1, attempted second-degree arson, count 2, arson, preparation to burn real property, count 3, arson of personal property less than $200. This is a habitual offender's second offense notice. Also, Mr. Rice is charged with 2260502. Count 1, second-degree arson. Count 2, arson, preparation to burn real property. This is habitual offender's second offense notice. Appearances.
Good morning, Your Honor. Eric Decker, PA 59316 people.
And good morning, if it may please the court, Sarah Robinson, P63181 for Mr. Paul Rice, who's present via Zoom.
And Mr. Rice, can you state your full name for the record, please?
Paul Anthony Rice.
Thank you. Good morning to you.
Good morning. You're
So
right.
as you stated, thank you. Attorney Robinson, you stated that you spoke to the forensic center and that Mr. Rice is being interviewed next week.
Yes, I spoke to Ms. Muir at the Forensic Center this morning. And they said that he will be evaluated next week. He's on the schedule for next week.
Okay. So Mr. Rice, I heard you ask about personal bond. This is what I'm gonna do. I'm looking at the file. It says here that your bond was continued. Judge Larry Williams didn't adjust your bond. I'm going to order a DSU report. That's a pretrial services report. They can give me more information to make a determination about your bond. And I'm not gonna make that determination until I get the report until you're evaluated with the forensic center, okay?
Okay.
So next week you'll be evaluated, and whenever I get the DSU report, I'll have the clerk call your attorney and we can go back on Zoom. It'll be an unscheduled date whenever we get the report, and then your attorney can address bond, okay?
Okay.
So it usually takes about 5 days to get the report, so it should be right after you're evaluated. That's what it usually takes, okay?
Okay.
Thank you.
And then Attorney Robinson, for the competency hearing, do you want to set out another 30 days?
I think that'd be safe, Judge.
Okay.
So I'm gonna have to wait all the way 30 days before I hear back?
No.
No.
Okay.
We got two things going. I'm sorry, go ahead, Judge.
So March 9th for the competency hearing. And then once we get the DSU report, we'll let you know. And then you can zoom in and we'll fall into the Wayne County Jail.
Thank you.
Thanks.
Mr. Rice, you understand what just happened?
For the most part, I should be hearing back about, I'm not all the way for sure about once the attorney hears back and she contacts the jail, how would I go about that? Will I have to come back before a judge, or will I just get a tether?
No, you'll come back before me and I'll have the report and we'll go over the report and I'll make a determination of whether I will adjust your bond.
Okay. All right, thank you.
Thank you.
You're welcome. So for the second matter, for the competency hearing, we'll schedule that for 9 o'clock.
Okay. All right, thank you.
You're welcome. Anything else?
No, Judge, thank you.
All right, you're welcome. Have a good day.
All right, you too. Thanks, Your Honor.
You're welcome.
Do I have number 2 that has some hallway work here?
Yeah. So, Mr. Decker.
Yes.
Attorney Perry.
can you hear me? Yes, Judge, I can hear you. Still don't have a competency report back from me.
Attorney, well, I'm gonna handle this one case, it's not a whole, and then, we'll come back to your matter.
Thank you, Your Honor.
Sir, how do you say his last name?
Yeah.
Okay. We're on the record, this is people of the state of Michigan versus Nathaniel Renard Alfonso Lagan, case 2260207. Mr. Lagan is charged with what kind of weapons carrying concealed the day that they set for a preliminary examination appearances?
Good morning, Your Honor. Eric Decker, P8593, people. And good morning, Your Honor. Good morning to your staff. Honorable Court. Mohammed Nasser, P74485, appearing on behalf of Mr. Nathaniel Lagan, who appears standing to my right. Sir, can you please state your full name for the record?
Nathaniel Lagan, Nathaniel Renard Alfonso.
Good morning to everyone. Okay, so Attorney Nasser, it's my understanding that you scheduled or asked for an early date. The court said, okay, you contacted the prosecutor, Ms. Parrish, and let her know. She said that it would be fine as long as we didn't receive a negative, know that the officer could be here, but there's some new information.
Your Honor, we did get a negative no, but it was late in the afternoon yesterday. And I understand that I'm speaking with the officer in charge. He believes that the officer will be available next week.
Okay. We're only 30 minutes before the actual scheduled time today. At this point. And your officer is not available today.
No, Your Honor.
Anything from defense?
I did receive the email from the prosecutor, so I believe it is court's discretion. We are ready to proceed.
Mr. Jackson, you said may be available next week.
I said the officer in charge let me know that he believes he will be available next week. I can't confirm that right here in front of you right now.
Okay, Officer, is it Robert?
Yes, ma'am.
Good morning.
Good morning.
Do you have any more information about whether the officer will be here?
Just from the emails, it just seems like he did ask to, be another day, because he couldn't make it. He does work at another precinct, so I'm not hands-on with him day to day, but it does look like he will be available next week.
Okay. So if you're not available next week without a motion, I'm going to dismiss. Next week, we have a very busy, every day is busy. So I leave it to defense counsel, whatever day you pick, whatever time we'll speak it.
Is he on?
The third.
No, the judge. I mean.
Oh,
Oh, okay, I got you.
Judge, I do have an in-person sentencing. I'm slammed next week myself, but in-person sentencing next Friday, the 17th, that will be at 9 o'clock, so we can do it at perhaps 10:30, 10 o'clock.
So the only thing is, I'm not going to be here on the 7th. It'll be Judge O'Connor.
That's fine. I don't know what you want.
All right.
Yes, sir.
10:30?
Yes, please.
Thank you very much.
You're welcome. I'll put notes in here, so you'll know what's going on.
Thank you, Judge.
All right.
Have a good day.
You as well.
Thank you.
Next Friday, 17th.
March 17th? I'm sorry, February 17th.
Yes, sir. Thank you. Okay.
Thank you. Thank you, Mel.
Thank you. Have a good one.
Have a good day, Judge. Be safe.
No, I'm sorry. For Harper, it's gonna be a waiver. I gave the case to Ferguson.
Okay, Attorney Watt, we're back on the record and with your client, Ms. Ford. Appearances?
Good morning, Your Honor. Eric Decker, PA 5931 to the people.
And good morning, Your Honor. Coral Watt appearing on behalf of Ms. Ford. Back on the record.
She was present on the call. She had, she called and dialed in. She did not have the video, so she was present and she did state her.
Yes.
Okay, so I allow Mr. Decker to have a little more time to see if he could figure out what the issue is with discovery being provided to you, Attorney Watt. Mr. Decker, do you have anything new?
I don't have anything new, except for the fact that I will this afternoon personally attend to this issue and get there, figure out what's going on, and hopefully by the end of the day today, Ms. Watt will have discovered.
Okay, so with that, Attorney Watt, I can adjourn it one day, and if you come back in tomorrow with no discovery, I'm going to dismiss the case.
Yes, that would be great, Your Honor. Thank you.
Okay, so you want to do it first thing in the morning, or we'll be here all day, so.
I'll try and let me just look really quick. I think my schedule is crazy tomorrow, so I'm gonna see whether I need to, do you start at 8:30 or 9 o'clock, Your Honor?
8:30, unless somehow daycare situation gets a little messy.
Okay, I'm gonna try and log in at, I'll log in later, like around 9:30 or 10 o'clock, because I have to be in the building at 10. So I'll just log in or stop in around that time, like around 9:30, 9:45, if that's okay with the court.
That's fine. All right, so I will see you tomorrow at 9:30, 9:45.
Thank you, Your Honor. Have a good
You're
day.
You too. 30 or 45.
Okay.
Okay. Attorney O, good morning.
Morning, Judge.
How are you today?
Good. Sorry for the delay, Judge.
That's okay. I just wanted to get you in before we start arguing. Mr. Buckley is here. Do you need to speak to him before we go on the record?
No, Judge, we spoke yesterday and this morning.
Okay. Let me call this case. We're on the record. This is the people of the state of Michigan versus Eric Otis Buckley, 2161100. Mr. Buckley is charged with one count of larceny in a building set for a probable cause conference today. Appearances?
Mr. Buckley here.
Good morning, Your Honor. Eric Decker, PA 5931 for the people.
Morning, Judge. Gleno with NDSP 83424, appearing on behalf of Mr. Buckley, who's present via Zoom. Mr. Buckley, please state your name.
Eric Buckley.
Good morning to everybody.
Morning.
Okay, Attorney O, do you have any discovery issues?
Judge, we have neither paper nor digital discovery. We're requesting both.
Okay.
Your Honor, I have a note here. This is my bad again. This looks like an Attorney General case, so I apologize for putting my appearance on it.
I see.
Okay.
Okay. So last time we were here on February 2nd, the Attorney General was not here either. Or the AG's office was not present, nor was Mr. Buckley.
That's correct, Judge. We adjourned it so our office could have time to locate Mr. Buckley, and we were able to do so.
Okay, you did your part. So have you spoken to the AG's office?
But Judge, we have requested discovery from them.
And you didn't receive it from them?
Sorry, Judge, can you say it one more time?
You just requested and received nothing in response?
Correct, Judge.
What did you request, if you don't mind?
I don't personally know because our team administrator sent out discovery requests. I just see a note in our system that discovery has been requested.
Okay. Attorney, do you have something else to send to? I'm going to call the Attorney General's office right now.
I do, Judge. When would the court like me back?
Give me 5-10 minutes. If that works.
Thank you, Judge. Yes.
Okay. Mr. Buckley, just hold tight.
Thank you.
Mr. Jones?
Yes. Your Honor. Good morning, Your Honor. My client is approximately 12 minutes away, Your Honor.
Wait, I can't hear you. Your audio is really bad.
Your Honor, my client's 12 minutes away.
Who is your client?
Michael Johnson, Your Honor.
Unknown caller. Okay. He would be in a different courtroom.
This is Judge Jefferson.
This is Judge Sabree.
Oh, I'm in the, is this courtroom 438?
Yes, she's 439.
Okay, my apologies. Sorry, Your Honor.
You are. Have a good one.
All right. All right.
Now, Mr. Hart. Everybody ready? Yes.
Lauren Anderson, LAURENANDERSON.
Okay, we're on the record. This is the people of the state of Michigan versus Ricky Cortez Harper, 2355164. Mr. Harper is charged with 1 count of stolen property, receiving and concealing a motor vehicle. This is a habitual offender for offense notice. Today is the date set for a preliminary examination. Appearances?
Morning, Your Honor, Eric Decker, PA 5931 for people.
Good morning, Your Honor. Neighborhood Defender Service by Lauren Anderson, P85191, on behalf of Ricky Harper, who is present in court tonight.
And Mr. Harper, can you state your full name for the record, please?
Ricky Harper.
Good morning to everybody.
Good morning.
And is it correct? Attorney Anderson, right?
Yes, sir.
Lord Anderson. Is it correct that your client is going to waive his exam today?
That is correct. I've gone over his right to a preliminary examination. He would like to waive that.
Okay, Mr. Harper, I'm going to ask you a couple of questions, okay? You have to say yes or no, answer them audibly so the court reporter can hear you, okay? Do you understand, or I should ask, is it your wish to waive your preliminary exam today?
Yes, ma'am.
Okay, do you understand you have a right to a preliminary examination?
Yeah.
And before I continue, Mr. Decker, do you have an objection to the waiver?
No, Your Honor.
Okay, back to you, Mr. Harper. Do you understand that if the preliminary exam were to be held, that the prosecutor would have to show at the probable cause standard, which is lower than the beyond reasonable doubt standard, much lower standard, but still a standard, that the charge that I just read was committed in the city of Detroit and that you probably committed that crime?
Right.
Okay, do you understand that?
Yes, ma'am.
Okay, and by waiving your exam, the prosecutor does not have to present any evidence today.
Right.
And you also understand that you're not waiving your right to trial. You still have your right to trial across the street at Frank Market.
Okay.
I always tell people that too. Okay. And did anyone threaten you or force you to waive your preliminary exam today?
No, ma'am.
Okay, and did anyone promise you anything in exchange for you waiving your exam? Okay, so I find your waiver to be freely, understandingly, and voluntarily given. So I'll have you bound over to Third Circuit Court, Frank Murphy Hall of Justice, and your arraignment on the information will be February 23rd at 9:30 a.m.
Thank you.
Anything else?
On behalf of the defense.
I have everyone's signature on here, except for the prosecutor.
Oh.
Okay. Thank you. Is everyone signing?
No, I'm sure. Oh, yeah.
That's right. Okay, Attorney O, I called the AG's office and left a voicemail and asked them to contact the court. Nobody called back, nobody answered the phone.
Judge, would the court hear a motion?
Sure, let me get back on the record. Okay, this is a recall, people of the state of Michigan versus Eric Otis Buckley, 2161100. Mr. Buckley is charged with one count of larceny in the building. There's a set for a probable cause conference appearances.
Good morning, Your Honor.
Oh,
I
right.
can't. Yeah, this is the AG case. Yeah.
Mr. O,
Good morning, Judge. Plano with NDS PA 3424, appearing on behalf of Mr. Buckley, who's present via Zoom. Mr. Buckley, please state your name again.
Eric Buckley.
okay, and Mr. O, as I just stated off the record, I contacted the AG's office and left a voicemail. No one answered the phone in regards to this case, and we have not received a response as of yet. And you asked if I would entertain a motion. Yes.
Judge, defense is moving to dismiss without prejudice. The AG's office can refile if they want, but they've clearly demonstrated they have no interest in prosecuting this case. This is an adjourned PCC. Defense is requested discovery, and now the court has reached out to the AG with no response.
Okay, and I did leave on the voicemail that you, Attorney O, did contact them to receive discovery, so they were on notice that they had a case here and they did sign the warrant. So with that, I'm going to dismiss this case without prejudice because, as you stated, Attorney O, they have not shown interest in moving forward and prosecuting this case. So, Mr. Buckley, your case has been dismissed.
Thank you, Your Honor. Thank you, Mr. O.
All right, you all set?
Thank you.
Oh, Mr. O, before you log off, I have a question. You have an 11:30 exam?
That's correct, Judge, for Ms. McWilliams.
Okay. Do you know yet whether or not that's gonna, well, I guess you have to wait to see who shows up. Okay. I'll see you later.
Those will both hold if the witnesses show, Judge.
Okay, thank you. I will see you then. That'd be great.
These cases. You want me to do it?
Everybody else, Selby? And this is the people of the state of Michigan versus India Renee Selby, case 2260892. Ms. Selby is charged with count 1, carjacking, count 2, weapons, felony firearm. Today is the day set for a preliminary examination appearances.
Good morning, Your Honor. Eric Decker, PA 5931 for the people.
Good morning again, Your Honor. Neighborhood Defender Service by Lauren Anderson, PA 5191, on behalf of India Selby, who is present in court.
Ms. Selby, can you state your full name for the record, please? India. Thank you. And are both parties ready to proceed?
Yes, Your Honor.
Yes, sir.
Okay, and we can address the tender issue after.
Yes, please.
Okay. All right, any preliminary matters?
The mutual sequestration for any and all witnesses, Your Honor.
Okay, I'm sure the defense joins.
We would join in that motion.
Okay, for the record, there is no one else in the courtroom but staff, the attorneys, and Ms. Selby. With that, Mike,
Your Honor, the people called Devon Alexander.
okay.
Step around to court reporter. Yes, sir.
Is there first, please come to me. Here first. Sir.
Not that close, but over.
Ms. Alexander, I swear you swear to raise the right hand. You swear to tell the truth, the whole truth, and nothing but the truth. Okay. Now go ahead and have a seat, take your time, and make sure it's in your microphone. Microphone, so the reporter, we don't hear you, okay?
Okay.
Yeah, that's like that thing. Whenever you're ready.
Maybe you-
Before we begin.
Yeah, so really quickly, could there be, for the mutual sequestration order, could there be an exception for the officer in charge?
As long as there's no objection.
Judge, I have no objection as long as he's not a witness in the case.
He is not, Your Honor.
Okay,
Okay.
that's fine. Whenever you're ready.
Mr. Alexander, good morning. Please restate your name for the record. Let's, is there anybody in the courtroom today that maybe you recognize?
Yes.
Okay, could you maybe point them out and tell me something they're wearing?
Green,
Make sure you speak up.
a green uniform.
Okay. And may the record reflect that the witness has identified the defendant?
Yeah, no objection. So reflected.
Okay, so how do you know this person that you identified as the defendant?
We used to be at a park together, you know, playing basketball and stuff like that.
How long have you known her?
Like 2 years.
2 years? Okay, now, how do you normally communicate? Do you have normal communications?
I mean, not really, but like we would probably text on Instagram or something like that.
And Mr. Decker, I'm sorry, just for the record, for the ID, you didn't state her name.
Pardon me?
You didn't state her name.
I apologize. The witness has identified the defendant, India Selby.
Thank
Thank you. Let's go back. So you said, how do you usually communicate with Ms. Selby?
Probably on like Instagram or just catch her at the park.
Okay. So let me take you back to November 22nd of 2022. Does that?
Yes. Yes, sir.
That sounds like a familiar day to you?
Yes, sir.
Okay. On that day, do you own a car?
Yes, sir.
Could you describe that car?
It was a no, I mean, what kind of car we had? A Ford Fusion.
Okay. Do you remember the year?
I think it's 2010.
Okay. So on that day that we just discussed, were you in the area of 19635 Mitchell Street in the city of Detroit, County of Wayne?
Yes.
Why were you there?
Sell a camera.
To what?
Sell a camera
To who?
to India.
Okay. How did you know that you should be there at that time?
I mean, I usually sell stuff at night, so I ain't never know that something like this happened.
Okay. But what made you go? Was there a communication that?
Just to get some money, you know, had to get extra money, so.
Okay. I guess what I'm asking is who told you to be at that location?
Myself.
When you you just told yourself that you wanted to be at that location?
Yeah, but I wanted to go get this money, so.
Okay. Is it what? Were you there to meet anybody?
Yes. At the same time.
Who were you going there? Who were you there to meet?
India.
How did you know to meet her there?
We text off Instagram.
Okay. So just to make sure I heard you correctly, that you heard that you talked to India over Instagram?
Yes, over
Objection,
Instagram.
asked and answered, they established the fake paper.
Okay, I heard it the first time.
Thank you. Okay, so when you arrived at that location, what happened?
She came in the car with her brother, which I didn't know who he was. And, you know, I ain't seen her in so long, so we was talking like, how you been, what you been up to, what you been doing since you been gone and all stuff like that. So I guess her brother left the car for like 2 or 3 minutes.
Objection speculation.
Excuse me, Your Honor. We have, can you step to the mic?
Yes,
Speak.
objection speculation.
Thank you.
You might be able to just say it louder.
Yes, I'm sorry, Judge.
And, Mr. Alexander, make sure you pronunciate it because these masks are making
Okay,
it hard for everybody.
Okay.
Yeah, the masks make it.
Okay.
Okay, let me see, where were we? So.
Oh, wait, there
So
there
you,
was, Judge.
y'all want me to keep on?
1 second, Mr. Alexander.
Judge, I would object to any kind of speculation about what the other person was doing, only what you saw directly being done by these.
So, Mr. Alexander, when you're answering a question, you can't guess, okay? You know it, answer it. If you don't, say
No, I know what I'm talking about.
okay, so re-ask the question.
Just tell me what you saw. It's, so what did you see happen?
What you got me, but what did I see happen?
Well, you said you saw some people get out of the car. Right?
They got in my car.
They got in your car, okay. So then after they, who got in the car?
India and her brother.
Okay. And then after that, what happened?
We chilled for a minute. I told you, I asked her, me and her was talking, like how you been, what you been up to and stuff like that. Then her brother left the car for like 2 or 3 minutes. They asked me to go to the store.
Okay.
I said, okay, bet.
So then what happened after that?
I guess her brother went to go get whatever he went to go get for the store. So he got back in the car, then went up to the store.
Okay.
After we went up to the store, they got what they got, and, we came back. Now, when we coming back, she asked me, do I want to come in? I said,
Come into where?
I guess to the house they was at.
Okay. So then what happened after that?
We getting out the car. We walking up to the house, I guess they was at. India and her brother was in front of me. So when we walking like towards the house, getting close to the house, her brother, like, I'm in front, so we walking.
Okay, so just really quickly, so what you're saying is that you were in front of who?
No, I was behind them. Them two was in front of me.
Okay, so they were in front of the 2 people, one of them, Miss Selby and this other person, they were in front of you?
Yes.
Okay.
We walking to the house. Then, her brother, so he turned around and pointed the gun at me. And
Did you see the gun before he turned around?
No, but he was saying like he had one and stuff like that.
Okay. What did the gun look like?
I want to say like probably a 9 or a 40. So I really don't know my guns, but it was like a big one.
So it looked like a big gun?
Yes.
Okay, so did he point it at you?
Yes, he pointed like somewhere like right here on my body.
Okay.
If you say right here, Mr. Alexander, just imagine for the court reporter, we have to type it down. Can you tell us where you're pointing to?
He pointed at his side of his mid-torso and his side.
Right side?
Yes, ma'am.
Thank you. Okay, so he points the gun at you, then what happens?
And I was in a shocking moment. He like, bro, give me your keys. I'm like, bro, you for real? He like,
I would object to hearsay. We keep mentioning things that this other man is saying over and over, but all of that is hearsay. He's not charged, so it's not a furry opponent.
Any exception?
I can't hear you, Your Honor, sorry.
Judge, I would object to hearsay. The statements made by the other individuals who are not charged would not fall under a furry opponent because he is not a person in this case, nor is he a party to this case.
The statement against interest, Your Honor, as far as any time.
Yeah, that's the same.
Yeah,
Yeah, because, he is in charge.
Yeah, fair enough. Okay, so just tell me what, so they pointed a gun at you, then what did you do after that?
Judge, I would also object to go forward.
Sorry.
It's been very clear that there is a man pointing a gun, not Miss Selby. So I would object to use of the word they and ask that we specify who's doing.
Okay, just re-ask the question.
Okay, when he pointed the gun at you, then what did you do?
no, I'm like, bro, you for real? He like, yeah, hurry, and then he like, hurry. He like, hurry up before I shoot you.
Judge, I would re-urge my objection to anything this other third non-charged person is saying.
The same. So, Mr. Alexander, you can't speak on what Ms. Selby's brother said, okay? rules of evidence. You wanna, you just, I know it's a lot of rules here today. I know you wanna tell your story, but you can't speak on what her brother said to you unless the lawyer say you can, or I do, okay?
Just tell me what he did, so then tell
All right,
me,
he pointed a gun and
and then what did you do?
gave him my keys.
Okay, so then after you gave him the keys, what happened after that?
I just like, you know, ran a couple questions.
So then after you ran, I'm sorry, go ahead.
Then I called the police.
They called the police after that. Okay, then what happened after that, if anything?
They took a long time to get to where I was at. And I was just there. Nothing.
All right, nothing further.
Good morning, Mr. Alexander. My name is Lauren Anderson. I represent Ms. Selby. I'm gonna ask you some questions. If there's anything you don't understand, let me know, okay?
Yes, ma'am.
Okay, you just stated that you called the police and spoke with them, right?
Yes, ma'am.
And they came after a while and you were able to speak with them?
Yes, ma'am.
On that same night, right?
Yes, ma'am.
You also gave a statement that night, right?
Yes, ma'am.
About 2:13 a.m.?
Yes, ma'am.
So within a few hours of this, right?
Right.
Okay. And nowhere in that statement did you mention you were there trying to do anything with a camera, right?
Didn't I tell you all about the camera?
I'd ask you to talk to me, okay, Mr. Alexander?
Okay.
Would it refresh your recollection if you had the chance to look at your statement?
Yes.
May I approach you? Mr. Alexander, take your time, review your statement, okay?
Okay, ma'am.
Mr. Alexander, has your memory been refreshed?
Yes, ma'am.
So you didn't tell the police that you were there to sell a camera, right?
Right.
You didn't tell the police anything about being there to try to get money, right?
Right.
What you told police is that she had invited you over to hang out, right?
Right.
To chill, right?
Same thing.
Right, but that's fair, right? You weren't
Yeah.
there for any kind of money, right?
Can I say something?
Sure.
I did talk to her over the phone about
Okay,
the camera and stuff.
no, my question though is you didn't tell the police anything about that.
Right.
Okay. Now, Mr. Alexander, I want to take you back to when you first started hanging out with Miss Selby that evening, right? What was her demeanor like?
What her demeanor was like?
Yes.
Chill.
Chill.
How she normally is when we was hanging at the park. Just, hey, Dad. So like, really.
Okay. And when the man you called her brother got back in the car, did that demeanor change at all?
Yeah, cause it's like, why would you bring your brother,
Okay. What about when the man pulled out a gun? Did her demeanor change at all?
hers?
Yes.
At the time, I wasn't really paying attention to her. It was like her brother.
Okay. So you don't know how Miss Selby reacted when the gun was pulled out?
No, but I feel like if she ain't tell me, can I say something?
No.
Oh,
You can answer my question.
Oh.
You did not see how Miss Selby reacted when the gun was pulled out.
no,
Now, you never saw Miss Selby with a gun in her hand, right?
no,
And Miss Selby never told you, give him the keys, right?
no,
Miss Selby never said to give him the keys,
Objection,
right?
you're saying this is the defense offering the statement of the defendant into evidence.
Judge, I would say it's not being offered for the truth of the matter of whether or not the keys were actually handed over, just to affect on the listener.
I'll allow it.
Miss Selby never said to give her the keys, right?
right,
Miss Selby never told you to give the other man the keys, right?
right,
That was all coming from the other man, right?
right,
Now, did you ever hear Miss Selby call that man by any kind of name at all?
no.
How familiar did she seem to be with that?
Yeah, it's also speculation.
Yes, it was close.
Hold on, Mr. Allen. That would be speculative. If he doesn't know, he doesn't know if he does. So the relationship, you can ask if he knows the relationship.
Certainly, and I'll get to that first. Thank you, I'll move on. Mr. Alexander, you referred to this man on direct examination as Miss Selby's brother, right?
Yes,
Why did you refer to?
because she said it was her, I never knew she had it.
Okay, now, when you talked to police that night, you said you don't know if that was her real brother or just somebody she would call her
Yeah.
brother, right?
Yes,
So you don't know if that person is Miss Selby's brother, genetic brother, right? Okay. Sometimes you refer to brothers as friends also, or friends as brothers rather.
right,
Okay, so that could just be somebody that she just met, for all you know, right?
right.
Okay. Now, when you met with police that night, you said that Miss Selby set you up, right?
Yes,
Okay, and that's because you had some conversation on Instagram to meet up?
right,
Okay. Now, you didn't overhear any kind of conversation that she was having with this man, right?
no,
You didn't overhear any kind of conversation about setting you up to take your car, right?
no,
So you have no way of knowing right now if Miss Selby actually knew that the man was gonna do that.
I feel like I do know.
Okay, you have no way of really knowing what happened,
Because
right?
if she ain't tell me that,
Objection, that's the answer, he said he felt like.
yeah, because if she ain't,
Mr. Allen, you don't have to answer.
oh,
You asked, said you felt like.
Okay. Mr. Alexander, you never saw Miss Selby helping that man in any way, right?
no,
Okay.
it's just.
You never saw the man hand India the keys, right?
I don't know what they did after that, man. I just ran.
So you have two people that you hung out with that night, right?
Right,
One of them is Miss Selby that you have a relationship, right? You
Right,
met her, right? And she was acting normal and pretty chill, right?
yes, ma'am.
Okay, and then these two people are walking away from you, and one of them pulled out a gun. Right?
Right,
And said to give you the keys, or give him the keys.
yes,
Okay. And you weren't looking at Miss Selby, you said, right?
no,
And you said you were so scared that you ran off, right?
yeah,
You were actually so scared your shoes fell off, with no police, you didn't even have your
Right.
shoes off, right? So you didn't see what Miss Selby did after that, right?
no, but when, her brother did the situation, the way like she was walking. Oh, the way like her brother pulled the gun out and she just walked away, she didn't say like stop or nothing. I was like, yeah, she had something to do with it.
I'll stop you, Mr. Alexander, you said she walked away.
Yeah, when her brother, turned around, like, but give me the keys, she just, acting like it was normal, just, walked away and stuff like.
Okay, I'm gonna stop you, Mr. Alexander.
Okay.
You told us a minute ago that you were only looking at him, right?
Yeah,
Okay. So now you're telling us that she was acting normal and you actually did see what she was doing?
she was, it's common sense.
Well, so, Mr. Alexander, I'm asking you very clearly, okay? What did you see Mr. or Miss Selby doing when the gun was
She
pulled
just,
out?
when we was walking to the house, she was just walking, like, when brother put the gun out, she just kept walking to the house.
Okay, so she left,
I don't know what she did, and I wasn't really thinking about
right?
her.
Because you were paying attention to the man pointing a gun at
Yeah,
you. Okay. So you never actually saw her helping that man in any way?
no, this could have been, Like, and
Okay.
so,
I have no further questions. Redirect.
Nothing, Your Honor.
I have one question. Mr. Alexander, did you see the two individuals leave together or do anything together after the gun was pointed at you?
no, I was on my so far, I didn't really know, no.
Any questions based off of my question?
No, Your Honor.
All right, Mr. Alexander, you can step down. Thank you. Just wait, Paul. Any other witnesses?
No, Your Honor.
Any from defense?
No witnesses.
Whenever you're ready.
Your Honor, the people motion for bind over to Third Circuit Court on the count of carjacking. The question of fact has been established and the people reserve time for argument.
Your Honor, the people are seeking to bind over on this carjacking charge, essentially under an aiding and abetting. If this unknown gentleman had been in a court today, this would be a very different kind of case. We would be specifically talking about his own actions, but instead we're talking about the actions of India Selby. And so it would be under an aiding and abetting here. The aids or abets within the meaning of the aiding and abetting statute describes any type of assistance given to the perpetrator of a crime by words or deeds that are intended to encourage, support, or incite the commission of that crime under MCL 767.39. The general rule is to convict a defendant of aiding and abetting. The prosecutor has to establish the crime charged was committed by the defendant or some other person. The defendant performed acts or gave encouragement that assisted, and that's the key word, assisted in the commission of that crime. And the defendant intended the commission of that crime or had knowledge that the principal intended to commit that crime. And we haven't heard any evidence of that today. Your Honor's own question at the very end, did we see anything happen after the fact? The answer was no. We did not hear any kind of testimony that Ms. Selby knew there was a gun, that she knew this unknown gentleman was going to turn around and point a gun, that she in any way said, go ahead and give him the keys, that she herself asked for the keys. We've heard nothing at all about any kind of encouraging or assisting this unknown man in any kind of way. Now, if the prosecutor wanted to offer any kind of more evidence, they could have, but they didn't do that, Judge. So all we have is this carjacking happening in a silo without any kind of evidence that Ms. Selby actually knew about it or aided or abetted. And so, Judge, we would ask that you not find over.
Your Honor, the people disagree with the recitation of facts. We do agree that this is an aiding and abetting theory. However, the entire reason why Mr. Alexander was at that location was because he was solicited by the messages from Ms. Selby. So it seems like the entire
Judge, I
reason.
would actually object to that because now we've heard that he was there to sell a camera to Ms. Selby.
That you said solicited, right?
Well, yes, she said that the entire reason why he was there was to meet with her.
And the testimony that we heard from him is that he knew the address because of her, but today he all of a sudden is saying
I
that
think
he
it's
was
clear that he came because he was meeting the client.
right, but I would object to the word solicited, that she goaded him over there or something.
Well, just
I
words,
can't hear. Sorry.
she can't hear what you're saying.
Judge, I would just object to the word solicited. I would object to the word solicited being used because that's not the phrase that he used. He was there to sell a camera.
Okay, when you're soliciting for buying stuff, that's the word used. So.
I'll move on. Or allow Mr. Baker to move on.
He was there because, sorry, may I continue? So he was there to meet with the defendant, Ms. Selby. It seems to me that that meets the definition of assisting a person to engage in this carjacking. It seems to me like, and the defense has several questions, and those sound to me like a question of fact. So this means that this is now ready for a trier of fact at the Third Circuit. Thank you.
So as the defense counsel, Ms. Anderson stated, this is an aiding and abetting case here, pretty obvious. So the issue is whether or not Ms. Selby assisted gentleman that Mr. Alexander spoke of in carjacking Mr. Alexander. So I will read the aiding and abetting requirements. So one, the prosecutor has to prove at this stage at the probable cause standard, first, that the alleged crime was actually committed either by the defendant or someone else. That's not an issue. Two, Second, that before or during the crime, the defendant did something to assist in the commission of the crime. I believe people have met the burden and probable cause standard to assist the gentleman by bringing Mr. Alexander to the location and using him to whatever they're doing, leading them to chill or to sell. But Mr. Alexander knew Miss Selby and they were friends, or they always chilled in the park, and took advantage of that relationship to get him to that location. Third, the last element, at that time, the defendant must have intended the commission of the crime alleged, or must have known that the other person intended its commission, or that the crime alleged was a natural, probable, and probable consequence of the commission of the crime intended. I do think that people have met, I think this was a setup. And no, Ms. Selby did not say, and usually criminals don't say when they're saying a crime, committing a crime together, hey, let's rob Mr. Anderson, or let's rob Mr. Alexander right now. Hey, remember we talked about it last night, let's do it together. So you're not gonna get evidence of that, but you have Ms. Selby who brought her, what Mr. Alexander described as brother, who may not be blood or not, to the location, in his car, and they both walked into that location on Mitchell Street and had the complaining witness in the front. And as Mr. Alexander stated in his testimony, Ms. Selby never said, stop, don't do that, or anything saying that she did not want to be a part of that crime. So with that, I'm gonna have Ms. Selby bound over to Third Circuit Court for the writing on the information for February 16th at 9 o'clock. And I know we still have to address with Selby's bond.
We do, Judge. Last, I believe it was Thursday, we came in to address the tether issue because her tether had died. And she showed up at the tether office to get a new charger. And Your Honor reissued a release so that she, because she had gone in with her tether, showing that she doesn't have any kind of intention to flee at any kind of intention to report date. However, she was brought in. She still has not been released after 7 days on that tether, which is much longer than the 24 to 72 hours that typically clients are waiting for a tether. Your Honor, judging from the fact that she has appeared, she did appear in the tether office, if there's any way that she could actually be released without having to wait for that tether and be on a personal recognizance bond, we would request that at this time.
Your Honor, the people would say that the tether seems necessary. We hope that will continue as part of the bond. As far as anything else, I'm not really all that familiar with what happened last week, so. But it seems to me like with the charges that Ms. Selby is facing, it seems to me like a tether would be appropriate.
And the tether is appropriate, and that's why I ordered it, so that she would be in custody, so that they would know, or the tether unit would be able to keep up with her. I just had a meeting at the office, and how long it's been taking for people to get there.
Judge, would it be possible to reissue the release order with the tether over just in case something has gotten lost?
So I want to do more than reissue. I'm trying to figure out who to contact to tell them that she needs to be released today, because it's been 7 days. And it's no longer following the order. We wait the 24 to 72 hours, but it's past that point. So I know Ms. Selby has to go to the back, but what I will do, I will reissue the order, but also contact the tether unit, Wayne County Jail, myself, to have her released the next week for 48 hours.
Thank you, Judge.
Per the order from, and I have the original order here from February 2nd.
Thank you.
Yeah, you're welcome. Anything else?
No, Judge, not.
Okay. Ms. Selby, I'm going to call over to see what took so long with the order back, okay?
Thank you, Judge.
Attorney Hayes. Good morning.
Can I go in the hallway?
Yeah.
Just want to make sure I'm okay.
No. Good morning, Attorney Hayes.
Morning, Your Honor.
I just received information that he was not brought to Wayne County Jail.
That was the text message I received as well.
Okay, I'm probably just as frustrated as you at this point. So I have supervisor in here who is trying to figure out what our next day could be, making sure that he's rented out for Wayne. And I tried to catch you before you came in person. I didn't want you to come down here and waste your time.
Your Honor, I appreciate that.
Okay.
I can tell you the interns are disappointed that they're not going to get to run an exam today, but there'll be other days.
There will be other days. I'm actually disappointed. I'm familiar too much with Mr. Eddie Flood at this point. I'm ready to get this case.
Okay.
So I'm trying to see if we need, I know it'd be safe to do 2 weeks out. So I guess we just have to wait for defense counsel
Yes.
to get a date.
Okay, thank you. I talked to the administrator upstairs, so she said you have to go to the Wayne County Sheriff. She's gonna. Not to the Wayne County Sheriff to be involved. She said it's gonna take 5 weeks.
5 weeks.
So. Yeah, but she said they have to schedule, we have to go to the Wayne County Sheriff. I told her the person is in Oakland County, right? So she don't call me right now. With the number.
Okay, Attorney Hayes, you want me to just have the court call you when we have a date for when everyone's back on Zoom?
That's fine, Your Honor.
Okay, I'm sorry, I had nothing for you.
No, that's fine. Whatever works. The only day in 2 weeks that I definitely cannot do would be the 21st.
Okay.
And I'm wide open the 23rd. The 23rd is the only day in February you don't have court scheduled. So if we can schedule the 23rd, that'd be fantastic.
Okay, and I was just told 5 weeks. I'm gonna hope that that's correct, but if it takes 5 weeks, I will let you know that as well. Oh, we have somebody on the phone now.
Take how long, Your Honor?
5 weeks, that's a very long time.
Your Honor, if that ends up being the case, can you let me know? Because I think our office can expedite it. I mean, usually we're pretty good about being able to get people within 5 days.
Okay, I'm calling.
Okay.
Thank you.
I can't make any guarantees, but especially just from Oakland County, like it seems like that's not.
It shouldn't be that, it shouldn't be that difficult.
That's my thought.
Is it too much of a hassle for your office to do it?
No. I mean, we already have the templates, like, and initially we started doing it with the first round of this, but we were told that the court would handle it, so we kind of retracted doing that. But I'm doing one already for Judge Giles' court on another case in 2 weeks. So
yeah.
Could you? I mean, I don't know what's happening. I have no idea. It's too many issues to me
today. So we're trying to do
whatever you want me to do, Your Honor, I'm happy to do.
trying to get somebody out from Oakland.
Attorney Hayes said
He's from where? Oakland County Jail, right?
Yeah.
Correct.
Okay, from Oakland County Jail.
Okay, so you want to set it for the 23rd then? That works for you?
If that works for you, Your Honor, that would be great, and I'll, get everybody squared away. You want me to send Mr. Harris a text message real quick, see if that works for him?
Could you? I appreciate it.
A couple of days. His name, what's that person's name? Eddie Flint. Yes, and he has 2 cases.
And then I see Kowinski is the other attorney.
Pardon me, Your Honor?
I have Kowinski as the other attorney.
I have Mr. Harris on it.
Okay.
Wait, let me let the judge hear that 1 second. You want to hear that? Oh, okay. Okay, we can get it. I'm gonna tell her. Okay. Okay. Oh, he don't. Oh, the AG. We've been doing it for a month. I've just been talking. Well, what's your name in case I ever have to call again? I appreciate your help. Thank you. I will. Thank you. Bye.
Thank
I know, I got it right here.
Judge, I'm sorry. Oh, no. It was irritating. Still would not.
Candy's great, just whatever. Rachel.
Attorney Harris, good morning.
Good morning.
You got the news?
Yeah, I got the news.
Okay. Attorney Hayes has been helping me out here. Does the what day did we say, 23rd work for you?
23rd, that week I'm in trial, Judge.
Okay. I'll make whatever day works between you two. I'll squeeze you all in and make you a priority.
Okay. Let me talk with him, Judge. I don't have my phone on me yet. Let me talk with him and I'll get back to you.
Okay.
Or get back to your clerk at least.
Okay.
Okay, thank you.
You got wheels on, you
Yeah. Your Honor, I'm sorry, just to clarify, do you want me to do the writ once we agree upon a date?
That would be wonderful.
Okay, I'll take care of it. I'll get Mr. Harrison, get a date, and we'll get back with the court.
Yep, just whenever, if you just zoom in and let us know the date and I'll say, okay.
All right, thank you, Your Honor.
Thank you. Right, in that case, okay, that's not the 11:30. Need a break, right? Or 11 o'clock is- Yeah. All right. We're gonna take a 5-10 minute break. That's what we're waiting for.
5-10 minutes?
Yeah.
Okay. Are we holding on that?
No, let's go see.
I got all
There's nothing that makes me. All these lawyers are talking about something that are common sense, so I'm feverishly looking for that now.
Oh, okay.
It's not a normal part of my site.
Yeah, I've heard.
In Texas, they're like, that was not Michigan.
I believe it was actually, I believe it was in New York.
Huh?
It was in New York, I believe.
Was it New York? So I'm trying to put it up really fast.
And and the ruling was that it was extremely narrow, only for certain states. I'm sure not one of those states.
Oh, but. Sometimes we litigate until the law changes. Sometimes you hit a point. That's 135 feet.
Yes, that's it. I have read the summaries.
Right, look, the Kiss Association is good.
Yep. Yeah.
So yesterday at the gas station,
Really?
people, we saw, and he went inside. Some of them, I'm not. Something that really. Oh, God. How sorry this move over here?
Less than a year.
Okay.
Yeah.
So you're a juvenile before?
I was, this, law is my second. Used to be
Oh.
and now, yeah. Yeah. I was a radio host for many years. I just started, thank you very much. I just started, the prosecutor's office.
Oh.
And I guess I'm. So that's what.
Oh.
So this is, so yeah, I'm hearing exams for.
Did you always have an interest?
Yeah.
Oh, that's good to know. Okay, radio was your.
Initial career, yeah. But, yeah, eventually tired of doing it, right? It's always nice to, when you're 40 years old, to be able to switch.
I mean.
Thank you. So what? So. So. We can't put no tenants in. Okay. Okay, cool. All right, so what? Yeah, I picked up like last week. Yeah, I do like. I give my customers over the 10 that you suggested. Yeah, so go. Because I do a very good job with that. You just hook my glasses up, get my glasses, yeah, to coincide with my outfits. Oh, let me tell you, it's fine. Okay, I'll be here to get pick them up, because I'm gonna wear all black tomorrow, red glasses. Yeah, okay, I'll see you later on. Thank you. Okay, all right, bye-bye. That's what's my song. Just checking on your nerves, though. Breathe 2 times if they shot, 1 time if you work out. We almost. read. I got the notes. That's how I came to it. Okay. Don't worry about it. Okay.
Oh, that's. I recognize.
So she was. I said,
That's
I didn't have time to, I wasn't here yet. Thank you, because you. I'm running late. She was like, okay, so she is pointing out. I don't know what her office said, no, no, we have to change it to,
Yeah.
She lost something. I don't care what time. She don't please my question. I read on you. She said. What's her name? She's. So what she said, act accordingly. Don't, because I'm not going to change my schedule.
Right, yeah. I didn't. She worked at.
Okay, understood. Everything she said, understood. Yeah, once you get her in, she'll be trying. She would. Until you get her in, she'll break down. Right. Understood. Yeah, okay. I'm gonna finish this up, and then I'll call you when I'm here. I'll give you a call. All right, bye. You don't know where it's at? No. Cause I'm like, help yourself. I don't know what. I don't know what I can take, what I can't take. What are you talking about when you say police report?
There's usually a report, some kind of report.
For this?
Yeah,
Okay.
thank you.
So when that just ask for the,
Request for warrant
yeah.
or investigators.
Yeah, the investigators.
Okay.
That's what you need, okay?
Thank
'Cause
you.
I didn't know what you was talking about. That's why I handed you the file.
Thank you.
You're welcome, hon. This case for time. You kept it, you kept it for 213 and 840. Position? Oh, I see, okay. All right, thank you.
Read that name so I can tell the prosecutor.
Me?
Which one? The name of Cedric Rose.
Oh, yeah, Cedric Rose.
Mr. Decker.
And I gave him the discover that order and to sign.
Who should be here on Monday?
I have no idea.
Because I just changed an exam to a P60.
Okay.
So I want to let whoever that is, no, so that the witnesses don't have to come.
One second. I just realized I don't know where I'm supposed to be on Monday either.
You want me to just send an email to Kirker and Derek?
Yeah, that would be great.
I'll do that, so you can get back to it.
Yeah. I tried to- Okay. Also, I tried. Do we can do this? All right.
I'm sure you all are ready on Adam. Yes. Okay. Okay.
All right.
Yeah.
Did you get a date? Did you? I'm not paying attention.
Yeah, one more day.
I'm just.
So wait on the.
Oh, okay.
On the 8th.
Okay.
Yeah. Fair enough. Yeah. I tried to get it.
So this one, you're done. I'm good.
Okay. Yes, well, I mean, I tried to get. in contact with the second, but it's, Yeah, I usually, I left a message on there. Thank you, sir. Thank you.
Yep, me too. I got a couple.
Yeah, that was a good time.
That's for me to negotiate with the prosecutor. They already gave you. This would be the deal that you turn down. We were on the Zoom with Judge. And they kept telling you about this and you. You know, you just.
You want me to say something?
I couldn't hear you.
Just like
Everything.
Or somebody gets here.
No, when I get here, I come in here, I'm gonna be your clerk for the multiple times that's on vacation. So okay, good. And I have everything set up for you, files, everything set up, your docket, everything. Yeah, I'll be here. I knew you wanted it, that's why I came in. We work well together. We get the job done.
Tell me I get a dream and I don't even know what he was. Because I thought.
Yeah, that's your attorney.
Cause I don't think I'm.
Hold on, go on there and talk to her.
It's so, I don't even know.
Don't say nothing.
Okay.
Walk right. God.
Wait, what's going on? What happened?
I guess the defendant and the defense attorney ain't on the same page. He like, I don't know what you're talking about. I didn't agree to this. He venting to me.
I had to remove myself.
I see you walk away.
I had.
Oh, man. I'm done. I'm out. I was trying to withdraw a long time ago. I'm not playing with somebody who's like tricky. I'm out. Okay, I'm not playing this game. He had a misdemeanor deal. Clearly stated, I don't want to, every time. Everything is recorded on Zoom, fortunately. Multiple times, over and over again. I'm done. I'm out. I'm making a motion to the program. This, I'm not saying it's good.
Yeah, people are ready to proceed.
All right, you need one day.
Yep.
You got the file? I got it.
Right now? Ready?
All right, we're on the record with the people of the state of Michigan versus Russell Tyrone Adams, case number 2260338. Mr. Adams is charged with 1 pound of weapons carrying concealed. Today's the date set for a preliminary examination. Appearances.
Morning, Your Honor, Eric Decker, PA 5931 people.
Good morning, Your Honor. Wendy Barnwell, P42505.
And Mr.
On
Adams,
behalf of Mr. Adams.
Mr. Adams, you state your full name for the record, please.
Russell Adams.
Thank you. Good morning.
Today is the day set for preliminary examination. Repeatedly, Mr. Adams was at PCC, offered a misdemeanor by Mr. Kal Najjar, aka Kal Najjar. This case got booted out of Judge Robbins because he repeatedly didn't want to accept a misdemeanor offer. We're here today. Now he's bringing me paperwork which would go to the same offer. And he's acting as though he didn't hear anything, never heard of anything. So I am done. I would respectfully move to withdraw from this case. I'm not doing it. I don't think you've ever seen me do this. I don't think you've ever seen me do this. But I respectfully move to withdraw because I perceive, well, I know there's a breakdown in communication, and I know so it's getting a little too tricky for me to handle.
What I heard motion hallway. Is that regarding the breakdown in communication?
Yes, yes.
Your Honor, just for the record, the people are, the people have no, have no knowledge of what deal was discussed at any time in this proceeding. So I can't stipulate to any deal that was offered.
So Kal Najjar would have notes in his thing.
Oh, Kal Najjar.
Kal Najjar.
Okay.
Kal Najjar. I know this court has heard of Judge Robbins.
Yes.
I can just bring this case here. This court was before Judge Robbins on multiple occasions. One occasion, my client didn't show up and they still got him here and all of that. And he turned down all deals that were made repeatedly. So I can hold this exam now, make arguments, and then vote. What is this? So it's now, there is a breakdown in communication. Can I talk to somebody? And I don't want to reveal anything. I don't want to reveal anything.
Mr. Adams, have you contemplated whether or not, or contemplated, I guess it just happened, hire another attorney? Can you answer my question first?
No, ma'am, I didn't know how to get an attorney or anything.
Okay.
And honest to God, ma'am, I don't even know what kind of deals I get.
Okay, that's
why I went to this class, because I thought I could go and take this class.
Okay.
And then they helped me out. I didn't even know about no deal. Everything I heard on the microphone was like breaking up and things, and we were resetting my cases and stuff. Me having a deal, honest to God, and I put my hand on the Bible and think, I don't even know what deals I had.
I heard you. So do you want that deal still? Is that what you're saying?
I don't even know what the deal was.
Okay, right to know.
That's the thing. I don't even know what my deal was.
So is it?
I'm lost when it comes into a deal.
Okay. Attorney Barnwell.
I would respectfully move to withdraw. I don't think there's a lot of honesty being said here. I perceived that when it was on Zoom, I perceived that something was a little off, and you have to have like a trust of somebody. Okay.
Okay.
And so I'm pretty straightforward. Everybody knows me. I've been around 35 years practicing. I'm a straightforward person. I fight for people. But when you're like tricky,
Mr. Adams, let me ask you this question. Are you interested in knowing what that deal is? Or was? Are you interested in knowing what that deal is or was?
Yes, ma'am.
Okay, what I'm thinking I'm gonna do, I'm trying to figure this out. I'm going to have Attorney Barnwell withdraw his counsel.
Yes, ma'am.
Would you agree that that's what needs to be done?
Yes, ma'am.
Okay. I want to, probably gonna send your case back to Judge Robbins with appointed counsel from Third Circuit Court, unless you want to hire an attorney. Do you want to hire one or do you want to appoint a
I'm
counsel?
not even from here, so I don't want to attorney. Okay. So, I would rather have somebody, because I try to call her and stuff and relate them.
We don't have to worry about the relationship
Don't
between you
worry,
at this
my
point. I would-
baby. My
You can hire
And
some-
first of all, I
You
can't
can
have
hire somebody
everybody
else for me.
talking at the same time. Just
You
one-
get somebody else for me.
That's what I just asked you.
Yes, ma'am, you can get somebody else.
Okay, yes or no question?
Yes, ma'am.
Okay, so I'm gonna have Kurt call over and get you appointed counsel.
Yes,
We're gonna
ma'am.
talk to that attorney today, and I'm gonna talk to Judge Robbins' courtroom to see whether or not that offer is still available. As Mr. Decker is not aware, I'm not aware, you're not aware, even though you may have been aware, I can't get into the details of that. I'm gonna give you the opportunity to, find out what that offer was, and whether it's still available, or whether you need to go to Judge Robbins or stay with me, okay?
Yes, ma'am.
Okay, so you can wait in the hallway while we get you an attorney. The attorney will call on Zoom, and you'll likely have to speak to your attorney.
I
through
don't even
Zoom.
have my phone.
I'm talking,
Okay.
on Zoom right here
Okay.
in the courtroom.
Okay.
And you can talk to the attorney in the courtroom. You don't need your phone,
Okay.
okay? And then you can decide how you want to move forward based off of me explaining to the attorney what happened, okay?
Yes, ma'am.
All right, so just wait in the hallway patiently. It may take about half an hour. We got one more case to handle, okay?
Okay, thank you.
You're welcome. So I'm officially withdrawing you from this case for 24 hours. So, exam will be adjourned. If not, it may not be done, so. All right.
Judge, I don't know if you guys are aware that they make deals with their. You know that, yeah, okay. It was more of a Second Amendment rejection type thing, of some other state and whatever. Done, can't take it anymore. I need to get a tougher skin, Judge.
Nope, I don't know.
Yeah, I can't stand my game being money by people who are playing a little game on a simple map. Okay. Unbelievable, but I'm done.
What's your name, sir? Good morning.
How you doing? Good morning. My name is Solomon Johnson. I came into court yesterday evening for 1:30. But nobody had let me in. So I don't know if it was for this one, for Aliyah or Adam.
Being Judge Aliyah Sabree or?
Yes.
We got traffic matters?
Huh?
You got traffic matters?
I believe so.
Okay, so I'm no longer on traffic, it's Judge Larry Williams. I'm gonna put the information on the screen. Call back in at 1:30 today. Email addressing.
It's just 3 Judge, did you tell that Mr. Adams to come back on virtual?
I told him to wait hallway.
Oh, okay. You want it virtual, right?
Yeah.
This is the number I have to put into the Zoom meeting?
Yes.
What'd you say, Mr. Johnson?
Is this the number I have to put into the Zoom meeting?
Yes, the number red.
At 1:30, you said?
Yeah, just go call at 1:30 and tell them what you told me.
You said call that number and tell them what I told you?
Yeah, so you called in yesterday for your court date, and you weren't heard. Email addressing.
All right, thank you.
So, he'll have tomorrow at 9 a.m.
Do you want to bring Mr. Adams back in?
Who should I put the German?
What I mean, I don't have to work. For, we found. Like,
I'm typing in now.
Mr. Adams, so the clerk just called over, I rescheduled your case, because it's gonna take a minute to get an attorney on screen today. So, tomorrow, we have your phone available, can you zoom in tomorrow? Okay, so I have the information, I just wrote it down, so you don't have to memorize it. Tomorrow, 9 o'clock on Zoom, you'll have a new attorney, and that attorney can talk to you and discuss whatever's going on. And, I will in the meantime see what's going on, whatever happened to Judge Rogers, okay?
Okay,
All right, so you have a new attorney, start fresh.
so just talk to her anyone?
Him or her, I don't know who it's gonna be.
Okay,
All right,
just call this, right?
Zoom, the Zoom information on your log on, that attorney will log on too. I'll put you on a breakout room, you all can talk.
Okay, okay.
All right.
I think.
You're welcome.
I have no explanation for her absence at this time.
Oh, she's not here.
Sounds like lunch to me.
Okay, we're on the record. This is the people of the state of Michigan versus Yvette McWilliams. Case number 2257091. Ms. McWilliams is charged on this case with 1 count of larceny in the building. And second case 1859582. Ms. McWilliams is charged in that case with count 1 uttering and publishing, count 2 uttering and publishing. This is an official offender third offense notice appearances.
Good morning, Your Honor. Eric Decker, PA 5931 for the people.
Good morning, Judge. Glenn with NDS PA3424, appearing on behalf of Ms. McWilliams, who is not present.
Ms. McWilliams, I'm getting ready to issue a warrant. I'm sorry. Literally just bought the text issue. Okay, Ms. McWilliams is here.
Let me go tell my witnesses that we are going.
Okay.
All right, people are ready to proceed, Your Honor.
Okay, on both cases.
Your Honor, the people are not ready to proceed on the case beginning in 1-8. The necessary witnesses have failed to appear.
Judge, defense means dismissed without prejudice.
Yes, I signed the form. We handle that after the next event. Okay. So for the remaining case for 1 count of larceny in the building, case 2257091, are the people ready to proceed?
Yes, Your Honor.
Okay, any preliminary matters?
Mutual sequestration for any and all witnesses.
Okay, and for the record, there's no one in the courtroom other than staff, both attorney and.
With an exception for the officer in charge, Your Honor.
Any objection?
So long as the OIC is not testifying, Judge, no objection.
He is not.
Okay.
Okay. All right, people call. All right. Mr. Williams. Charles Williams.
Charles Williams?
You see if my OIC is still here.
Take your time. Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. Okay, so take your time, have a seat right here in front of you, and make sure you speak up in the microphone, okay?
And just for the record, Your Honor, the officer in charge is not here.
Okay.
Has the witness been sworn?
Yeah.
Okay. Good morning. Please restate your name for the record.
Charles Williams.
All right, Mr. Williams. Now, are you employed?
Yes,
Where are you currently employed?
the Mercier apartment.
Mercier Apartment Group. Okay. What do you do there?
I'm the maintenance man, janitor.
Okay.
Janitor.
And so what is that? What do you do?
Basically what I do is keep the building clean and clean the apartments after the tenants move out and before they move in.
Okay. You do any maintenance?
The only maintenance I do is mainly the cleaning part of it. That's it.
Okay. Now, is there anybody in the courtroom today that you may recognize?
Yes.
Okay. Could you maybe point something out, tell me what they're wearing, maybe point something out?
Yeah, it's on the blue mask and like that.
Judge, like the foundation.
Can we, for the identification, can we get to why he's identified?
Okay. So you said that part of your duties is that you move out?
Yeah, like when people move out, I go in and clean the unit to make sure, you know, everything's up to par, stuff like that. I just clean it up because when some people move, it'd be kind of messed up. It'd be, you know, pieces of furniture, stuff on the floor and stuff like that. And so my job is to clean it up and, you know, change the toilet seat or whatever.
Okay.
Yeah.
Let me take you back to the day of August 18th of 2020. Do you remember that day?
Yes.
Okay. Is is there anything unusual that brought you to court that day that maybe happened that day?
I was on the side of the building working on my motorbike. It was I wasn't working the building, but it was some time I had on. And I was just asked to bring some tools. She brought some tools from
Who asked you to bring some tools?
Toya.
How do you know Toya?
She was a tenant in the building.
Okay. Now, is it possible that maybe that you recognize someone in the courtroom today?
Yeah.
Okay. Could you maybe point them out and tell me something that they're wearing?
Toya.
Tell me something they're wearing.
I can see. She has on no, she's right there.
Okay.
Around what?
Brown top.
Okay.
I'll let the record reflect, Your Honor, that the witness has identified Ms. Yvette Latoya Regina Williams. Okay. All right. So what happened? She asked for tools.
Yeah, she asked me about some tools of mine while I was working on my motorbike on the side of the building.
Okay.
Yeah.
So then what? So then after that, what did you give her the tools?
Yes, I let her go.
Okay. So then what? So did she tell you why she wanted the tools?
She just said that she was about to move out and she needed some tools. I didn't ask about why, you know, she needed anything.
Okay, so I think we left off with that you didn't give her the tools. You did give her the tools?
What happened when I went there, I recall that my bags, I left my bags on the side of where I was working on the bike at. When I went back over there, my tools were gone. And I asked her, did she get them? And she said, yeah.
Okay, so then what happened after that?
That was it for that day.
Okay. So so did you recognize her as somebody who was living in the apartment building?
Yeah.
So did you, so I understand that from your testimony, you said that one of the things that you do in your job is that you
maintenance and clean up the apartment.
Did you have an opportunity to clean up after
Yes.
clean up her apartment?
Yes, and when I went there to clean up, I noticed that the stove and the refrigerator wasn't there, and that's this is part of the building.
Okay. Just to be, could you actually just tell me what was missing again, please?
The stove and the refrigerator. It's stainless steel stove and the stainless steel refrigerator was missing out the unit.
Okay. So what did you do? What did you do after that?
I reported it to the management.
Okay. Who's the management?
The management, at that time was my sister, she left.
And then what if anything happened after that?
After that, I guess she told the owner, Mr. Murphy.
I'm sorry, I didn't actually hear what was that?
She informed the owner, Mr.
Objection, Judge,
Murphy.
hearsay? I can't hear, what he said. It would be the, perhaps, because it's his job, it's the state is being.
Hold on.
Okay.
The witness said that Sheila Sharp, his sister, property manager, informed the owner of something.
So, Mr. Wood, were you referring to Ms. McWilliams say something or to your sister?
No, I was, referring to my sister.
Okay, okay, what's your response?
My response is this is something that he does in the normal course of action as part of his job, and this is a statement that's being offered for the effect on the mind of the listener and not for the truth of the matter, sir.
I don't know what it is he's gonna say, so based on who's about to say it, I'm gonna say this, I'm gonna say it.
Okay. Your Honor, there's nothing further.
I'm sorry. Did you say his name?
Right, Mr. Williams, correct?
Correct.
Taking your attention back, you said you were at this apartment on August 18th of 2020?
Correct.
And on that day, you saw Ms. McWilliams, correct?
Pardon?
On that particular day,
Yeah.
you saw Ms. McWilliams, correct?
Yes.
And you were standing outside of the building, correct?
Correct.
And you didn't go inside the building that day because you were
No, I
not.
did not.
And you briefly spoke with Ms. McWilliams, correct?
Correct.
And do you recall sometime after that day, you went into Ms. McWilliams' apartment, correct?
No.
So when you saw Ms. McWilliams that day, you didn't see Ms. McWilliams moving any further,
No.
correct?
No, I didn't.
You didn't see Ms. McWilliams moving out a refrigerator,
No.
a microwave,
No.
a gas range.
I didn't see her move out anything.
And at some point after August 18th, you do go in Ms. McWilliams' apartment, correct?
Not that day.
Not that day. That's
Correct.
exactly my question. What day do you eventually go inside Ms. McWilliams?
About 2 days later, so probably about the 20th.
And Ms. McWilliams had been moved out for a period of 2 days at that point, correct?
That's about right.
And in that 2-day period, strike that. You're the maintenance man for the apartment complex, correct?
I'm the janitor.
You're familiar with the layout.
Correct.
Were there any security cameras in that apartment?
No.
So no security cameras whatsoever.
Only on top of the building. Not in the building.
Okay, did you have an opportunity to review any of that security
No.
camera? Did the police ever come ask for that security footage?
I don't know.
1 second, Judge. No additional questions, Judge.
Just one, the tools that Ms. McWilliams said, so what were they?
Vice grips, shoe wrenches, and socket wrench.
With your experience in,
An objection, Judge. It sees the scope of cross. I did not explore that during cross-examination.
No further questions, Your Honor.
Mr. Williams. No, it's a thing.
I can do that.
Yeah, thank
Your Honor, the people call Patrick Mercer.
I just need the lawyer. Oh, you want the signature? Okay.
Hi. Patrick. And we are CI.
Okay, I'm gonna swear you in. Swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Okay, so have a seat right here in front of you, and make sure you speak up to the microphone.
Okay.
Whenever you're ready.
Good morning, please restate your name for the record.
Patrick Mercier.
Okay. Are you employed?
Self-employed.
Self-employed? When self-employed, doing what?
We have, my family has apartment buildings in the city, 6 buildings.
Okay. What do you do for that?
Manage and renovate and run our property.
Okay. And what does that entail?
Finding new tenants, showing apartments, collecting rent, renovations, putting in cabinets, counters, kitchens, painting.
Okay.
We self-manage and operate. We don't have any management company.
Okay. So do you have any interaction with the with your tenants?
Sure.
Is there somebody in this courtroom that maybe was a tenant of yours?
Yeah.
Okay. Maybe you could point them out and tell me something that they're wearing?
Brown clothes.
Okay. Let the record reflect that the witness has identified Ms. Yvette McWilliams, the defendant. Okay. So is there anything about Ms. McWilliams that would bring you to court today?
Yes, she stole a refrigerator and a
Objection,
stove.
Judge. Lack of foundation, false speculation.
I'll rephrase. How did you come to meet the person you just identified as the defendant?
She was a tenant in our building.
Okay. So when was the first time you had a conversation?
I don't know exactly,
I'll try.
My office is in that building, running the tenants all the time. We have live-in managers. I don't show every apartment to we have 350 units. I work in 6 different buildings all over the city.
Okay.
So.
So you did say that she was one of your tenants.
Mm-hmm.
Okay. Do you know if she still one of your tenants?
No.
Okay. Why is that?
Because she wasn't paying her rent.
Okay. So usually when somebody stops paying their rent, then what happens?
We send in a notice for non-payment and start the eviction process.
Okay. Did that happen?
Yeah.
With Ms. Williams? Okay. So did you have an understanding that she was going to be leaving the apartment?
Yes.
Okay. So during that process, what happened?
She starts the move-out process. Let the manager know what day she was moving out. She got a U-Haul and.
Objection, Judge. Lack of foundation, lack of personal knowledge. He hasn't testified that he was personally there to observe any of them moving out. All this information potentially be hearsay.
The response would be that he's just simply telling me what he knew about with this particular tenant of what was going to be happening. But it's not.
Speaking to the move out process, Mr. Mercer, you're saying that you called you? Ordered?
What?
Do you know that a U-Haul was used?
I did not see him personally. I heard from my manager on site.
Okay, so it's not relevant anyway to me at this point.
Okay.
But so it's the same.
Fair enough. Okay, so what happened with so you said that you were missing some appliances?
Correct.
Okay, how did you find that out?
From my manager.
Judge hearsay.
Don't know yet. What do you say?
Okay.
I found out from.
A document could be, he just said from my manager.
Okay. And that I would say that is offered, that's offered for the effect of the mind on the listener.
I don't know what he said.
Oh, I apologize.
What he.
Okay. How did you find out that he was that there were some appliances?
From my manager and my manager.
Okay. So what did you do as a result of that?
information.
I called Ms.
An
Williams.
objection, Judge, again, renewing my record for hearsay, the information that property was taken, an element of the offense. He learned from his manager, Ms. Sharp, and maintenance man, Mr. Williams.
Was this through verbal communication?
Yes.
Okay, so it'll be here.
Okay. So let me ask you this question. So in your units, what kind of appliances are usually in the units?
Fridge, microwave, and stove.
Okay. Do you recall maybe what is there a particular brand that's in every one of these?
I know the refrigerator that was in that unit was a Hair refrigerator. I do not remember the brand of the stove, and I'm pretty sure it was a Sharp microwave, but I'm not positive.
Okay. Do you recall what the value was for any of those particular items?
Yes.
Okay. Do you remember what the value is for the refrigerator?
About $1,000.
Okay. Do you recall what the value was for the microwave?
They're about $500.
Can I just ask what location, what unit are we talking about?
Oh, I apologize. What is the address of
66 Adelaide Street.
Okay, is that in the city of Trenton County, Wayne?
Yes.
Okay.
And that around the corner.
And that's the address that we're talking about?
Mm-hmm.
Okay, so in that particular address, was there anything missing?
Yes.
What was missing?
The stove and the refrigerator.
Okay. So did you have to replace?
Yes.
the stove and the refrigerator? Okay. And those carried the value that you spoke of?
Yes.
Okay.
I spoke with her about this. She called me.
Okay. Okay, so.
I have evidence that's not here.
Objection, Judge, there's no question on.
You have to wait for a question.
Oh.
And I'm sorry, I'm sorry I'm being slow. With okay, so I very much apologize, Your Honor.
That's why I take your time.
Taking my time. So you did say that you had to replace those. Do you know that there was a total of how much you had to replace?
It would be about $2,500.
Okay. Now, the address that you gave for the particular apartment where those were missing, who was renting that apartment?
Mr. Williams.
Okay, nothing further.
Correct, am I pronouncing that correctly?
Yes.
So you're the owner of the AMO apartment building located on 66 Adelaide, correct?
My family is correct, yes.
And you have multiple employees working on you, correct?
At that building too.
And that's Ms. Sharp and Mrs. Williams.
Mr. Williams.
And Ms. Sharp handles the day-to-day of the operations, correct?
She was the manager, yeah.
She's the property manager.
What?
She's the property manager, correct?
She lived there, she was the manager.
And you said there are over 350 units in that apartment?
No, that's what we own in the city. You ask if I have that building, or he asks if I'm there every day. No, that building has 66 units.
And so when somebody rents an apartment, you don't personally do all the showings, correct?
I don't, but I did in that one.
Okay.
And it was brand new, freshly remodeled. So I was there a lot because I run the remodels. I buy all the appliances.
And was anybody else on the lease for unit 52?
No, we don't have leases. We're running the month.
And so when did you first learn that the stove, refrigerator, and microwave were allegedly missing from the unit?
Allegedly missing is what you're saying?
Correct.
Well, they were missing, wasn't alleged. And I went there that Monday after.
You remember the date?
I think I have a calendar there.
think it was the 17th of August 2020. But that's, I just have a calendar of when, anyway, about that day.
And so when you learned that these items were missing,
Mm-hmm.
you didn't observe anybody taking these items, correct?
No, they were
You
taken
didn't
the day
observe,
before.
you didn't observe Ms. McWilliams taking the refrigerator.
No,
So
no, but she told me she took them. I talked to her on the phone, she told me she took them.
And did you record that call?
I did not record it. I don't record my phone.
And are there security cameras in the apartment?
Not in it, but out on the outside. But they may not have been there then.
What angle is the security camera pointing in on that?
I don't know that they were installed by then.
There were no security cameras.
I would imagine we probably would have tried to get it. I would say no at that time, but we probably would have tried to get the deal.
Did you file a police report in this case?
I did.
And did the police eventually come out to the scene?
I think they came out there. I filed it with the detective Billings. I know that. I have the name and email address, and I know we spoke on the phone a couple times. I think he came out once, but you know, this is now whatever it is, 3 years ago.
And did you provide a witness here, the detective building?
I gave a report of the missing property that Ms. McWilliams took, yes.
But did you go down to the precinct and provide a witness here?
I didn't go to the precinct. I think he came to me. We spoke on the phone. I did not go to the precinct. I know that. I called it in and gave it over the phone, and then I think he came out. But I'm not 110% positive of that. Pretty sure I met the guy.
Additional questions, Judge?
No, Your Honor.
Mercer, you're all set, you sit down and I'll wait for my quick result.
No, Your Honor.
No, Judge.
Your Honor, the people motion for bind over, we feel like obviously the question of fact has been established on count one larceny in a building. This is ready for the trier of fact, and we reserve time for argument.
Judge, we would object to the bind over mainly because there's been insufficient evidence, even by a probable cause standard, of an essential element of larceny in the building, which is that the property was taken. There may be evidence that the property was moved because there was testimony from Mr. Williams that once they were inside the apartment after the fact that certain items were missing. There's absolutely no testimony whatsoever that it was Ms. McWilliams who took the property or moved the property. No eyewitness accounts, no security camera, no police investigation whatsoever. For those reasons, because there's a lacking essential element, we're objecting to the bind over.
Oh, yes, sir. Your Honor, the people disagree with the recitation of facts offered by the defense. Now we of course heard from Mr. Williams, who said that he gave the defendant tools, and then when he went into her apartment, he found that there were appliances that were missing. Seems like that is a question of fact for the trier of fact. We also learned on cross-examination of Mr. Mercer that the defendant actually told him at one point that she did take the appliances. So it seems as though that a question of fact has been established, and this is ready to be bound over to the Third Circuit. Thank you.
Okay, so I'm just gonna read the elements here for larceny in the building. First, the defendant took someone else's property. Second, that the property was taken without consent. Third, that the property was taken in this case, apartment building. Fourth, that there was some movement of the property. It does not matter whether the defendant actually kept the property or whether the property was taken off the premises. Fifth, that the property was worth something at the time it was taken. Sixth, that at the time that the property was taken, the defendant intended to permanently deprive the owner of the property. first element, that the defendant took someone else's property. Had Mr. Mercier not said it on his own, that he spoke to the defendant, and the defendant said that she took the property, this would not be allowed. Second, property was taken without consent. Mr. Mercier stated that the property belonged to him and his family's company. Third, that the property was taken in his apartment or his family's apartment building. Fourth, that there was some movement of property. Well, it's from both testimony, the appliances, in this case, we have stove, refrigerator, and microwave. There was movement as Mr. Williams testified that the appliances were not there. I think 2 days after he went to check the move out, as he does move outs, check to see what the state of the apartment was. And fifth, that the property was worth something at the time it was taken. Mr. Mercier did state that the value to replace the appliances was $2,500. And that at the time the property was taken, that the defendant intended to permanently deprive the owner of the property. I don't believe that there was any testimony that the property was returned. There's a probable cause standard. I do think the people have barely met, but have met their standard, based off of the elements here. And the fact that Mr. Mercier did testify that he spoke to the defendant, she said she took the property. Mr. Williams.
Let that man come by.
Are you talking?
I can't.
You don't need to say. So with that testimony, I'm going to have Ms. McWilliams bound over to Third Circuit Court for the regular information of February 23rd at 9:05 p.m. Anything else?
The other one was sent separate to the paper.
I have it in here.
Can you do this? Sign. It's all right. Thank you. Don't we need to do that other
Give us a
case?
second.
What happened? Yeah, what happened here?
You don't have to worry about that, Ms. Ellen. It's our problem. Waiting on the attorney to give us the date. You can put a dummy date in there if you want.
For what?
Like,
Oh, yeah.
you can get rid of that.
That's not, yeah, that's not. That's in G. Was it the 23rd?
Date doesn't work for attorney here.
Oh, okay. It's like a lottery.
Was he getting on his nerves?
Huh?
Was he getting on his nerves? Did you? Yeah, he was getting on that.
He said it was stolen.
Yeah, no, the way he was talking.
Oh.
Yeah, of course.
I heard her.
I'm like.
I just had it.
It was stolen, like, we have to
He act like you was getting on his nerves. Wow.
But as soon as I heard him say that she told me that, I was like, let's go home.
Because otherwise, you know what's about to be found out.
That's why I was standing there for 5 minutes trying to like, wait a minute. What am I missing? What am I missing? And then I sat down and I'm like, yeah, this is not getting bound over. And as soon as he said that, I was like, done.
Yeah.
Hi, I had a question. Do you know a Dr. Rashid?
What's the first name?
I actually don't know his first name, but he's my professor at school, and he said that he used to teach you.
Dr. Rashid.
Mm-hmm. He was like, I know her and her brother. I'm at Wayne County right now, but he's been a lot of different places, and he said he taught you and your brother.
Is it Wayne State?
Wayne County right now.
Oh, Wayne County.
Yeah, but he's kind of been everywhere. A professor for a while.
I have to now figure out who it is.
And I was like, oh, I don't know, but I'll ask.
Usually not say I don't know, it's like really.
Yeah. But I didn't realize he had a brother, so that's when I was like, oh, okay, and then I found that out.
Both of us.
Yeah, I noticed.
Right down the hall.
Yep.
Let's see. Yeah.
I'll see all you guys on Monday.
So you will be here Monday?
I will be here Monday with Mr. Kirker. Mr. Kirker is going to be here by himself.
Okay. What did I have Monday? That I need to talk to you about?
Yeah, there was an exam that you turned into a PCC.
Yeah, I sent it to Kirker and Terry.
Okay. So at least Kirk will know about it because he'll be here on Monday.
Yep.
Thank you so much.
You're welcome. Have a
Have a good weekend, you guys. Yep. Thanks.
Okay, I'm looking at professors at Wayne County Community College.
Okay.
That's your first name.
That's the only part I don't, because I just started his class on Saturday. I never got. He teaches philosophy, and I like it so far. It's pretty good.
I'm over here like, what? Because my older brother teaches, I mean, he's at Wayne County Community College.
Oh.
He's the dean.
Really? I didn't know that.
Oh. Is it?
Small world.
Rashid Shabazz?
Maybe. He's Indian.
Which campus?
He teaches at the Northwest campus and I believe downtown too. But I go to his Northwest campus. But he was really excited when I told him I worked there. He's like, oh, I know her. I'm like, okay.
He does know. I promise you that.
Yeah. I had a feeling. Because he referred to you by your first name, and I said, well, what's your last name? I don't know everybody's first name. And I don't know.
You know, probably from the Muslim community with Tommy and Leah.
Mm-hmm.
I don't know. I can't remember. I don't know. I don't even have his first name. Okay. Okay, you just gotta tell him I said hi.
Okay.
So I have to figure out.
I'll find out more information for you, I guess.
To make it seem like don't make it seem like I'm doing.
Okay, I mean, I can ask for me, because I don't even know it.
Then come back and tell me first.
Okay, I can do that.
You know, some people think, like, oh yeah, tell them I said hi.
Right.
I'm not. Fake.
Okay, well, have a good day.
What's your name?
Milan Johnson.
Say it again.
Milan Johnson.
Milan?
Yeah.
Okay, I know your name. All right.
Have a nice day, Yana.
You too.
Oh, you say put a dummy date out here for him? You here tomorrow?
I'm gonna come back tomorrow, or?
You want me to call them, let them know, just come back, Zoom me in tomorrow
The date.
with a date?
Just leave it the date. I don't know if it's the date.
Yeah, okay, I'll call him.
I can't be mad at them because the spinning was really out.
We good here? Okay.